What if everything you thought you knew about a family man turned out to be a lie played out in real time, right inside a courtroom? Welcome back to the channel. Today we are breaking down a case that has it all: an assault charge, a minor victim, explosive jail phone calls, a judge ready to drop the hammer, and a defendant who simply cannot stop talking, even when it is absolutely destroying his own case. This is People vs. Matthew King. And trust me, by the time we reach the end of this hearing, you are going to have a lot of questions about what Mr. King was thinking. Here is what we know going in: Matthew King has been sitting in jail for 2 weeks awaiting a preliminary examination. He is also, and this is critical, currently on parole for a prior conviction of witness intimidation and interference. Let that sink in. A man already on parole for tampering with witnesses is now accused of a new assault. And as the prosecutor is about to reveal, he has been busy on the jail phones. The victim in this case? His own minor son. We have a defense attorney pushing to move fast, a prosecutor pumping the brakes because new evidence keeps emerging, a judge trying to hold the whole thing together, and a defendant who decides mid-hearing that this is the moment to argue with the judge about his phone privileges. Buckle up. Court is in session. Let's get into it.
Court calls the case, People versus Matthew King.
Good morning. Joy Gaines, Senior Assistant Public Defender, representing Mr. King, who's present to my right. Would you please state your name, sir?
It's Tony O'Kane. How you doing, Mr. Sumter? I'm doing great, Mr. King. How are you? Good. All right. What are we doing?
Your Honor, we do not have discovery yet as of yesterday when I met with Mr. King. Miss Sunda, I'm assuming, because I emailed her at the same time regarding his as the other clients, that we will have it. Regardless, Mr. King wants to schedule the preliminary examination, and he is very much aware of where we are in this process. He is adamant that he wants to schedule the preliminary exam.
Your Honor, at this point, I would be objecting to that, given that I have come to find out there is more discovery. There's a second venue involved in this case that does have additional video surveillance of the actual assault that occurred in this case. Further, there's...
Okay, let's pause right here because this is important, and it sets up everything that follows. Discovery is the process by which both sides of a legal case, prosecution and defense, are required to share the evidence they have with each other before trial. It is supposed to level the playing field. No surprises in court. Both sides know what they are walking into. Now here is the problem: the defense attorney, Joy Gaines, is telling the judge that as of yesterday, they still do not have full discovery. And that matters enormously for a preliminary examination. A preliminary examination, or preliminary hearing, is not a full trial. Its purpose is simply to determine whether there is probable cause to believe the defendant committed the crime. But you cannot properly evaluate the evidence if you do not have all the evidence yet. So when defense says, "My client wants to move forward now," and prosecution says, "Wait, there is more evidence coming, including surveillance video from a second location," you have a fundamental conflict. Speed versus thoroughness. Here's the real question: is Matthew King pushing for speed because he is confident he is innocent? Or because he wants to get ahead of the evidence before it all comes in? Keep that question in mind, because what we learn next about his phone calls may give you an answer.
There'll be more discovery because I was planning to address bond today, so there will be jail calls that could be leading to other charges in relation to this case. So at this time, there are a few things in play here that I do not have yet, and that defense does not have yet, that I think would be very important for this case, along with another follow-up interview with the victim of this case as well.
My client still wishes to go forward with the preliminary exam as soon as possible.
Understands that if all of that's not there, or if we start the preliminary examination, that it could be adjourned if the people aren't entirely ready to go. That's fine. Pardon?
He said that's fine, Your Honor.
Been to jail 2 weeks. I ain't did nothing wrong. They always try to do.
Well, Miss King, let me just explain to you though. The problem's going to be you may be in there longer at, and nobody can go because they don't have the stuff, and your counsel can't even advise you as to what you need to do. I mean, so that's all I'm saying.
Mr. Simpson, can I say something to him?
Well, I was going to say, I know
All right,
that you and I talked about that, and you understand that, and you are anxious to get this case moving forward.
Yes, I get none of these days credited. I've been in jail.
Well, sir, I don't.
No, he's on a parole hold.
Okay.
Lying.
Here's what I'm going to do. That the discovery that you have now, you can get over to.
It was sent yesterday, Your Honor.
It was sent yesterday.
Currently, it was sent over yesterday. I'm awaiting further steps along with that surveillance video from where the actual assault occurred. And then potentially, and then Ms. Gaines would also get the jail calls that could be leading to future charges as well.
As to the witnesses currently charged, you would at least have police officers that could testify, correct? Because I'm going to do something with the date because everybody seems to be in a hurry. So I'm going to set an in-person preliminary examination.
Did you catch that moment? Right there at 2:46, Matthew King breaks from behind the scenes and speaks directly. He says he has been in jail for 2 weeks and he is not getting credit for those days because of the parole hold. And honestly, that frustration is understandable. 2 weeks in jail is real. Every day counts. But here's what he does not seem to understand: impatience in a courtroom can cost you. Because while he's focused on moving fast, speeding through proceedings before all the evidence is ready, the prosecutor is sitting there knowing there is surveillance video from a second location, jail phone call recordings that may lead to additional charges, and a victim interview still to come. The judge is trying to warn him gently: if you rush this, it could get adjourned anyway. And you will have gained nothing except more time in custody while your attorney is less prepared. So the question becomes, who does Mr. King trust more, his own instincts, or his defense attorney? Because so far, every time he has acted on his own instincts in this case, it has made things worse. And we are about to see just how much worse things are about to get.
Set it for April 28th, 2026, a few days. Hang on. 9 a.m. That's before me.
Right. Thank you.
As the bond.
Your Honor, it's come to my attention that since being arraigned, Mr. King has been making calls to his family, that includes his sisters, I believe his mother. In these calls, he says, my son don't need to come to court, man. You don't need to come. Talk to his mama. You're right there. If you want to help your nephew, you need to get on that phone and talk to his mama. That's what I said. It's going to kill him in the end. She's supposed to be on it. I would know what I would do. And further things telling them they need to talk to the victim's mother. The victim is his minor son, so he's asking them to talk to the victim's mother to try and get him to not come to court and to guilt him into coming to testify against his father. So I suspect this could be leading to future charges of witness interfering in the future. And we've not had a chance to go through all of the jail calls. These are just a few that occurred after arraignment. And Mr. King is also on parole for a witness intimidation interfering case as well.
Okay.
Your Honor, Mr. King did indicate to me that because this involves a family situation, that he had spoken to his mother.
Okay. Stop. This is the moment the entire hearing pivots. Let me break down exactly what just happened. While Matthew King has been sitting in jail insisting he has done nothing wrong, he has been on the jail phones, which are recorded, calling his mother and sisters. And in those calls, prosecutors say he is coaching his family to contact the victim's mother. Who is the victim? His own minor son. The goal, according to the prosecutor? To pressure the boy into not testifying against his own father. Think about what that means. A child, the alleged victim of an assault, is being indirectly pressured through family members to protect his abuser. That is manipulation at a deeply personal level. But here is what makes this situation even more explosive: Matthew King is already on parole for a prior conviction of, wait for it, witness intimidation and interference. He has literally done this before. He was convicted. He served time. And now, the prosecutor is saying He is doing it again from inside a jail cell, using a recorded phone line. This is not just a bond condition violation. This could be the foundation of entirely new criminal charges. And the defense attorney's response? She says she needs more context than what her client told her. About those calls may not reflect the full picture. That is a fair legal argument. But the recorded calls don't lie. This is exactly why courts say, when in doubt, say nothing. The question you should be asking right now, would you make those calls, knowing the phones were recorded?
And his sister. He has not spoken to his son or his son's mother, but his own mother. And everyone is aware of the allegations. He indicated that he does, to me, he indicated that he does have concerns about his son having to come in and testify and amplifying any potential issues between them. But he said to me when we were discussing that I did not have the discovery when I spoke with him yesterday, that he is prepared for his son to come and testify. So without more context, I think there may be more context than the statements alone are giving at this time. So the preliminary exam is April 28th. I know that you typically cease phone calls. I just want to reiterate that he has not had any phone calls with his son or his son's mother, but the exam is on
directing people to contact them. Same.
Well, I
cannot have only direct contact, Ms. Gaines. As you know, he can't have indirect contact.
Correct. I'm not disagreeing with that. I'm just saying that.
Let's give the defense attorney her due credit here, because Joy Gaines is doing exactly what a good defense lawyer should do. She is threading a very delicate needle. She is not denying that the calls happened. She is not saying Matthew King is innocent of the phone conduct. What she is saying is this: the fragments of phone call the prosecution has reviewed may not capture the full context of the conversation. Her key argument? Her client has spoken to his mother and sister, not to his son or the boy's mother directly. And he says he accepts that his son will testify. That is important because it speaks to intent. If he truly intended to obstruct justice, why tell his own attorney he is prepared for his son to take the stand? But, and this is a significant but, the law does not only prohibit direct contact with a witness. It also prohibits indirect contact. Meaning, you cannot use a third party, like a mother or sister, as a go-between to pressure or influence a witness. That is still witness tampering. The judge is about to make a ruling on his phone privileges. And the defense is trying to buy time by arguing for more context before that hammer falls. Was it a smart legal argument? Technically, yes. But as you are about to see, the judge has already heard enough. And what happens next is as dramatic as it gets.
Based on our terms of there may be more that we may not be getting the whole conversation in context, given how he told me the conversations with his family went.
All right. What I will do is I'm going to read the people's request. The defendant's phone privileges and texting privileges are hereby ordered revoked. Hold on, sir, do not do that.
You always take my phone. I haven't did anything wrong, Mr. Sir. I haven't did anything wrong.
Want a hearing on it? Because I'll have to listen.
Let's do a hearing today.
Want me?
Because I need to talk to my family. I have things going on.
Sir,
I want to do one today. Like you taking my phone, Mr. Simpson, and I ain't called them. The thing was, don't talk to my son. I haven't talked to him. I haven't contacted none of them.
Bond conditions were that you cannot have third-party contact or direct third-party.
I haven't.
Okay,
I haven't. Sir.
Are you going to listen to me? Because if you're not going to listen to me, then I'm not going to listen to you. Okay, you can shake your head all you want. I'm just gonna leave it there. We'll see you on Tuesday. You know, you respect me, I'll respect you, but I'm gonna do it. Yeah, we're gone. We're done.
And there it is. That moment right there, 7:45, is one of the most stunning things you will see in a courtroom. Matthew King, a man who is already in custody, already facing potential new charges for witness interference, already on parole for the exact same type of conduct, looks directly at a judge and says, "If you're not going to listen to me, then I'm not going to listen to you." Let that land for a second. This is not a street corner. This is not a heated argument between friends. This is a courtroom, the very institution that holds his freedom in its hands. And he has just told the judge he does not have to listen. Now, the judge's response was remarkably measured. He did not find Mr. King in contempt on the spot. He did not escalate. He simply said, "Take your head all you want. I'm just going to leave it there." Translation: I am a judge. You are a defendant. I hold the gavel. And I have already made my ruling. But here's what should concern Matthew King far more than losing his phone privileges. Judges remember defendants who treat the courtroom like a battleground. They remember the tone, the body language, the outbursts. When sentencing day comes, if it comes, that memory does not disappear. The phone privileges are gone. The preliminary exam is set for April 28th. And the jail call evidence may be building a second case against him in real time. Every single decision has consequences.
Court calls the case, People versus Danita Combs.
If you're on that?
Yeah.
People.
Let's bring it all together, because this hearing, short as it was, covered an enormous amount of legal ground. Matthew King is facing an assault charge. The alleged victim is his own minor son. From the very start of this hearing, the prosecution flagged that critical evidence is still incoming. Surveillance footage from a second location, additional jail call recordings, a follow-up interview with the victim, and the possibility of entirely new charges. Despite all of that, Mr. King, through his attorney, pushed to move forward as quickly as possible. The judge granted that request in part, setting a preliminary examination for April 28, 2026. Then came the bigger issue. The prosecution revealed that Mr. King had been making jail calls, directing family members to contact the victim's mother, an effort, prosecutors alleged, to pressure his son into not testifying. And remember, Mr. King is already on parole for prior witness intimidation and interference. This conduct, if proven, could expose him to a completely new set of criminal charges on top of the assault allegations. The judge's ruling on bond was swift and direct. All phone and texting privileges revoked immediately. Mr. King's outburst in response, telling the judge he would not listen if the judge would not listen, added yet another concerning element to an already complicated picture. The broader implication here is something we see again and again in cases like this. Defendants who refuse to trust the process, who try to control outcomes from inside a jail cell, often make their situation dramatically worse. Matthew King walked into this hearing with one set of problems. He walked out with several more. April 28th is the date to watch. The evidence will be more complete. The stakes will be higher. And we will be here to break it all down for you. If you found this case as shocking as we did, and honestly, how could you not? Make sure to hit